down in Chautauqua County, where we hold court every month, and hopefully for many more months to come. I don't think there's a more beautiful place in the state of New York and probably in this country than here in Chautauqua County, and one of the places I really love to come. I'm really thrilled to be introduced by a partner at Phillips Lytle. Phillips Lytle was in large part helped me along. I was 21 years old. I had just finished my second year of law school, a rather young law student, and they gave me my first job in the legal field as a summer associate. And as was mentioned, my first job after law school was as clerk for Judge Jason from the New York Court of Appeals. And my job as clerk required that I would go with him to Albany whenever he went to Albany, which meant that I sat next to him on more plane rides than I can count. And inevitably, he liked to talk, and he often would talk about Justice Jackson and his experience in terms of meeting with Justice Jackson during his experiences in Nuremberg. Bankruptcy is an omnipresent event in the life of America today. And I appreciated some of the remarks and some of the comments that were made earlier, because America has undergone a fundamental change in the last 30 years, and I'm just blessed to have come upon that fundamental change at an appropriate time. Mr. Benson, the first speaker today, spoke about changing conditions and globalization and changes in the basic nature of how businesses operate. On the consumer end, we've experienced enormous changes in the last 30 years. We have a new credit environment. Never before would we have people prior to the last 30 years using credit cards to the extent that they use them today. We have gambling institutions that become commonplace throughout the United States and indeed here in Western New York, with 4 gambling casinos within an hour or 2 drive of where we stand right now. We have an enormous increase of healthcare costs as well as healthcare opportunities, but with those opportunities come tremendous expenses. When I filed it, I had never filed a petition before, and our firm had no bankruptcy department. My advice would be 2 things. First of all, figure out what chapter you're filing and why. There are 3 types, primary chapters that you're going to be dealing with. Chapter 7, which is liquidation. Know what liquidation is. We have seasoned practitioners throughout this district, and it's not I'm not criticizing anyone because it happens all the time, who file a Chapter 7 and think that they can continue to run a corporate business during the pendency of the Chapter 7 proceeding. We deal with that all the time. That's not what Chapter 7 is for. Chapter 7 is a liquidation proceeding. Know what that means and what impact that's going to have on your business if that's the approach you're taking. We have Chapter 11, which is a restructuring of a business, an opportunity to develop a plan of reorganization over time, over a short window of time. It's a tremendous opportunity, but it's expensive. When I was in the private practice, my business was primarily Chapter 11 work, although I was also a trustee and represented committees, and I represented a large number of lawyers who ended up filing bankruptcy. In bankruptcy, in Chapter 11, it's an extremely expensive process. Reorganization is not cheap, even under the new amendments. But it is an opportunity, and know what you're aiming for, to restructure the business under the leadership of current management. And then you have Chapter 13, which is a personal rehabilitation of the debtor, primarily designed to preserve assets. It's primarily used by people who have assets to protect, whether it be a house that may be overly encumbered, a house that may not be fully encumbered. You use Chapter 13 as a process to avoid liquidation, either by the secured creditor or by the trustee if you're ending up going into Chapter 7. The second piece of advice I would give to someone who is newly filing is to follow the forms. Get a good software package and answer each question individually. If we have any problem that's generally pervasive among new practitioners, is they get a set of forms, they hand them to their secretary and say, fill this out. That is not the way to handle a bankruptcy. Each question is specific and there for a purpose. If you don't know the reason for the question, then you shouldn't be filing the petition until you figure out the reason. Each question is specifically designed on the statement of affairs. Each question in every one of the schedules is designed for a specific purpose. If you can follow the schedules, you will follow and understand what you're trying to do. If there's something that you don't understand, stop, ask a question, figure out why are they asking this question and of what significance is it to me. The major types of cases are 7, 13, and 11. If you file 7, the person that's your primary trustee, unless there's a conflict of interest, in which event we bring a trustee from Erie County down. But in almost all cases in Chautauqua County, your trustee is Tom Dory. And he's been trustee for as long as I've been a judge, even longer. He was a trustee when I was a trustee back in the early 90s. If you file a Chapter 11 case, there usually is not a trustee. The party that really handles the Chapter 11 process is counsel, and we have one of our foremost counsels in Chapter 11, Bill Savino. If you file Chapter 13, your case will be monitored, reviewed, handled, and a recommendation will be made to the court by our Chapter 13 trustee. And in the Chapter 13 office, we have 2 outstanding counsel. Our 13 trustee, Al McGavro, and his assistant counsel, Janet McDonald. They will handle every 13 that comes by, and not a 13 goes by without going through them. So they're here to answer your questions on 13. Normally, I can't talk to you unless either I'm in court or I'm in a forum like this. If you can't talk to me, the person you talk to is my law clerk, Adolph Iannicone, and I've been blessed to have him as my clerk since the day I started. In fact, he was 2 weeks before I started office. He has 2 weeks more experience than I do as a law clerk. He started under Judge McGuire at my request. And he's here really to, if I can't answer private questions, at least he can field them. Sometimes he can't answer them either because of ethical limitations. But we're basically open for questions, and if not, then I'll open with questions.